Hello, everyone. This is the Injured Workers Legal Side podcast. I'm Richard Fink, a lawyer who specializes in workers' compensation law.
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by WSIB, Ontario, with a specialization in workers' compensation and human rights law. If you want to reach out to either one of us to be part of our podcast, you can contact us through the links below. This week's topic is return to work with the accident employer. I just want to start quickly by saying that, and Richard probably recalls this too, is that in Ontario, the WSIB had changed their return to work process, where in the past, if you return to work with the accident employer, which is what we're talking about, that was return to work. If that didn't happen for whatever reason, they sent you for retraining, and I believe it was called Labor Market Reentry Program. So I just want to make that they've combined it all and they just call it all return to work now today, right, Richard?
Yes,
Yeah.
the requirement to return to work is actually contained right in the statute, the Workplace Safety and Insurance Act. I believe it's Section 40. It commands the employer to make available suitable work. There's even special penalties for employers with more than 20 workers or the construction industry employers, even if they don't have 20 workers. So there is a command on employers to make modified work available, and there's a command to injured workers that they have to cooperate in returning to work. So this part of the statute is obviously one of the great thresholds for the WSIB to keep its costs down because rather than the workers spending months or years recovering, they can be directed back to modified work post haste. In other words, as soon as possible. But there's a huge number of problems with the system. So I'll flip it back to Paul.
I would actually
First
add
take
that,
on problems.
yeah, I would actually say and correct you in saying it's not to keep their costs down, but seemingly it's to generate massive surpluses or in the business world, profits. Um, and that's one of the problems that when you look at it from the individual perspective, the system prior it started in 1990 with the change and the historic change from having one benefit to two benefits. And then at that time, they implemented return to work, but they didn't get very aggressive. In my recollection, they did more so with the further revision in 1997, 98. I mean, 97 with it coming into effect in January 1st, 98. Then the board itself, with its policies, and I believe it was under David Marshall, got aggressive with return to work, where they started implementing this everybody works system. And then I noticed in 2018, when I did the Freedom of Information request to the WSIB and found a very, very low number of workers being declared unemployable, meaning they can never work again on the position of the board. And I go back to that book that I have, The Insurance Bad Faith, that it is in private sector insurance. This isn't insurance. I know, and people are going to yell at me. I get it. And I just want to add one point about that, that to me, workers' compensation is like insurance, but it is very distinctive in the sense that the legislation took away an individual's right to sue the employer. And in return, they, well, used to give them the right to workers' compensation. No other thing is like that, and it's very unique. And I think that's something that should always be mentioned to make it distinct. But that said, in insurance case law, if an insurance company is not declaring a worker unemployable, it's actually considered bad faith and punitive and warranting of punitive damages. The other point I wanted to mention, Richard, was I have an article about return to work in the WSIB. The one thing that the WSIB and employers need to always consider, well, not consider, comply with, is the Human Rights Code. Um, there was a case, it's BOYCE v. Toronto Community Housing Corporation. And in that case, the author of this report was talking about the importance that while the board standard is here, human rights standard or human rights code standards and requirements are much higher on employers and even on the WSIB. And it's that, how would I say, friction between those laws and the almost at times complete ignorance to the human rights code. Like what frustrates me is when you read the return to work board policies, and they've changed, I've noticed. Before, Richard, it said something that would allow for unemployability where they would factor in other disabilities, even work injuries and stuff. And now they're just focusing on just the work injury. They're excluding the other categories that used to be considered by the tribunal in the various decisions. So that's very concerning as well.
The case that always comes up is if you're missing an arm before the work accident and you lose another arm from the work accident, you're a no-arm person as far as return to work goes, not a one-armed person. The WSIB often forgets that example. I'm constantly explaining that to injured workers when I speak to them. One of the cases I wanted to look at was 870/23 from the Appeals Tribunal, which is the worker can refuse suitable work with the accident employer if it's a hostile work environment. And example of a hostile work environment would be your manager is constantly berating you that you're not getting enough work done, in part, for instance, because your back is sore and you can't move as quickly. This type of case comes up most frequently, and the usual response when we're representing the injured worker is to call in the return to work case manager to act as sort of a mediator between the employer and the worker. But the return to work case managers have been rotating every 2 weeks, so they never get a grip on what exactly is going on. And their primary goal is get the worker back to work, as opposed to trying to say, enough's enough. This place is a hostile work environment. The fact that in this decision 870/23, the worker had to go to the appeals tribunal and argue the case, and the case was heard a year and a half ago, and argue this case is really pathetic.
Yeah, it's very frustrating when, and I can see the tensions at play, and most injured workers will go, yeah, who cares? But a good example of employer vicarious liability, it comes into play when I started to understand that. That's when I started to understand the issues at play, which is the people forcing the workers back to work are usually being done by either a covert policy or being yelled at or told to do this or else. And it's not that they're what we call as innocent morally or whatever, but legally you can't pursue them. That's where you'd go after the board or the employer. And a good example of that was in speaking of workplace toxicity or environment from this would be that famous case of Morningstar v. WSIB, where the worker experienced unbelievable um, a toxic workplace environment. That was a little different. It wasn't a return to work per se, and the employer was trying to say that the stress from the toxic workplace was work related. The tribunal agreed, but then the divisional court overturned it and said that she had a right to sue the employer. So it's a cautionary tale for employers to not just blindly go with what the return to work specialist or the case manager says, because they do have that civil obligation, but then also the human rights code comes into play that it puts a higher standard on the employers. And I would add to the board as well.
Let me look at another case, which is 255/22. The return to work job must be productive. So when the policy first started 25 years ago, employers would have workers in and they could spend their time counting the holes in the wall as their employment, given that they could sit and stand doing the job, there'd be no stress on their back or their joints. Over time, the WSIB has been looking at the productivity, but the WSIAC case 255/22, again, the WSIB didn't care that the work was or wasn't productive. The workers said, I don't want to do this. I'm not going to do it. I feel useless here. And it took the appeals tribunal to turn the matter around.
I would add too, Richard, in that is another factor is, and I strongly suggest employers and workers both go to the Ontario Human Rights Commission's website and review the accommodating people with disabilities policy on their website. It is very well written. It's very lengthy, and I say it's very well written because it incorporates case law into it from the Supreme Court of Appeal. And in part of that, it actually says that when accommodating people with disabilities, and by the way, an individual who claims benefits under the Workplace Safety Insurance Act, whether they're accepted or not, is considered a disability under the code, warranting of accommodations. So employers and workers should consult this guide. And getting to what you just said, to add the point, is one point that's made in there by the commission is you have to ensure that any accommodations are how would you say, dignity, like, they don't demean the person.
The next case I wanted to look at was 430/22. And it stands for the proposition that the worker is entitled to resign his modified work when the work is not sustainable. And those types of cases are you're given this job, say you're doing some driving around, but your job is not going to be there much longer because the employer obviously doesn't need this type of work. So it's not sustainable in terms of its productivity. It's not sustainable in terms of its long-term use. And that dealing with that and a return to work specialist, I'd say, is practically impossible. The position of the WSIB always is if the job is there and you're doing it and it meets your restrictions, goodbye, good luck, you're off of comp. So that again, that the worker had to go to the appeals tribunal and say, I resigned, then I got cut off from WSIB, and I resigned because what I was being asked to do, it was going to be complete and finished in a month or two anyways. And then what? There's nothing for me there. So that was an interesting decision.
Yeah, I think I read somewhere in the policy that the work must be permanent in
Yes.
nature.
The next decision I wanted to look at was 373/24, commuting for an hour and 20 minutes. And this is
Oh,
by
yes.
car, is not suitable, which always raises the question, which is why my staff, who also has to commute an hour and 20 minutes by car, but they're not forced to come in because they can work remotely. But to cause a worker whose normal commute time to work would be 20, 30 minutes, which is still significant, and then say, we're going to change the location for your return to work, and now you have to commute for an hour and 20 minutes. So come on in and spend 2.5 hours a day or almost 3 hours a day commuting is really a torture and shouldn't be forced.
That also would fall under the umbrella. See, this is where a lot of the return to work stuff I've noticed falls under the umbrella of human rights, the Human Rights Code and the tribunal. I remember representing a client last year where she was terminated based on a disability, and one of the acts of reprisal she claimed was she was demoted and then she was transferred to a location where the original place she was working at was a 5-minute commute, and then the other place was like an hour and a half commute. which then caused her family status, which is a nice one, an issue because she previously she had no trouble getting the kids off to school. Then in the other one, it wasn't. And family status would and does come up in return to work with employers and injured workers and stuff. Because I think one concept that the employers and the WSIB and injured workers don't realize is that prior to your injury, you were fine and the work carried on and everything's fine. Now there's a huge shift in your ability to work, and then they're modifying and changing things, which then has an impact on your dignity and on also, believe it or not, your family status and everything else.
So, if there's another case, which is 452/22, and in that case, the workers' beef about the job was that it was a 90-minute commute by public transit. And we have a lot of cases where the worker used to go by car, but has trouble sitting for extended periods of time because of a back problem. So they can't sit for an hour in their car. So one opportunity is travel for 15 minutes, then take a 5-10 minute break, and then another 15 minutes. So you can be traveling for 2 hours, or you could take public transit where you can walk around, stand up an hour and a half, and you're spending 3 hours traveling. You're spending 8 hours on the job. You're only awake for 15, 16 hours a day. Your day is cut down to, 4 or 5 hours of time that you have to your family and yourself, which
That,
is no way
Richard,
to live.
oh, sorry, Richard, you bring up a very good point that if you were like, you have to factor in the person's personal time. Like I say, there's 24 hours in a day. The average person, say, sleeps 8. Not me, but at any rate, so the other 16 hours, 8 is saved for work and 8 is personal life. So that's 50-50. So it seems to me, and I could be wrong, but when your doctor says, okay, Richard, you can work 4 hours a day, or you can function, not work, function 4 hours a day, that the employer and the board wants all that 4 hours. And I think that's something that also has to be considered as well, is the person's other time in doing things.
Or, if you're suffering from fatigue due to the pain in one of your limbs or your back, the WSIB always says you can work 8 hours. There shouldn't be any restriction just because they don't recognize pain. They actually state that in their decisions. They don't recognize pain. Pain is
Actually,
subjective. But
actually, oh,
if you've
sorry, go
got a
ahead, Richard.
bad back, and after 4 hours, you're in a lot of pain, the return to work should be 4 hours, not 8. And we have a large number of cases of on that magnitude. And the reason we have them is they become extremely contentious because the board always says 8. You can get doctors, even specialists, to say at 4 the worker is going to suffer significant discomfort. And the WSIB ignores those opinions.
There was a case that went to the Supreme Court, and I'm sure you know the one I'm talking about is Martin v. Nova Scotia v. Martin. And what I really found fascinating about that case was what the Supreme Court of Canada said about chronic pain sufferers. To me, chronic pain and pain is the same thing. The only difference is chronic pain is lasting, it's permanent nature. But the fact is that in that decision, two things, or at least two things, were identified by the Supreme Court. One is pain, according to the Supreme Court of Canada, is legally a disability and must be recognized under the code and the charter, which means when I say recognized, must be accommodated. Meaning, if you say you have pain, you have pain, that's a disability. Nobody can question that. Now, when you say, because of my pain, I require not to do this or to do this, they have to accommodate. The board or the employer can say, this is where I get a big fight too, is the board will say, well, you never provided any documentation. You never asked. The service provider or the employer has to make a request and has to pay for that documentation according to the Human Rights Commission's policy. Getting back to pain, the Supreme Court also said what was fascinating was they said that compensation officials, employers, and even doctors don't recognize pain and chronic pain when they need to. So this is something where people, oftentimes many injured workers, will not say that they're in pain. And to me, a good example, Richard, of pain is an indicator of something bigger. And what I mean by that is in your car, when you're driving your car, when that little red check engine light comes on, that's pain for your car. Do something. And unfortunately, when the board and employers and doctors say just work, like there's two types of pain. One is good pain when you go to the gym and you work out, and the next morning you're like, oh my God, I can barely move. That's good pain. Your muscles and everything are growing. But then there's bad pain. And that pain is the pain you cannot ignore, but you're told to do so. It's the same as putting black tape over the check engine light on your car, and then the engine blows up and the WSIB and your employer go, not my problem. This is a huge issue.
All right. Well, thanks again, Paul, for your help. Thanks to Pam, my legal assistant, for their help in helping us put this together. And we'll see everyone next week.
Okay. Thanks, Richard. Thanks, everybody, for coming.